A Minnesota man is behind bars after being accused of murdering his ex-girlfriend in a shockingly brutal attack, her allegedly telling officers what happened before she died, and this all ending with a crazy chase that ended with the defendant allegedly perched in a tree for hours. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. This shocking and deeply disturbing case started to unfold on June 18th, when 36-year-old Melissa Hunt, battered, barely conscious, clinging to life, pulled her car into a stranger's driveway in rural Kellogg, Minnesota. According to a criminal complaint that was filed in Wabash County, the homeowners immediately called 911 after finding Hunt severely injured with devastating facial trauma, including a shattered jaw, missing teeth. Now, remarkably, Hunt was still alive and able to speak, and she pleaded for help. Law&Crime, we obtained a copy of the probable cause affidavit, which includes a first-hand account of these harrowing moments when deputies arrived on scene. And despite her critical condition, Hunt was able to communicate with officers. Quote, the victim was able to communicate with deputies at the scene. She communicated that Craig, this is her ex-boyfriend and the suspect in this case, hit her with a stick. Victim attempted to say Craig's last name, Ham, but was unable to complete it. Victim then began to spell the last name. Victim was asked if she was trying to say Hameister, and she nodded yes. Deputies were quickly able to identify the man that Hunt was referring to, 44-year-old Craig Hameister, a former partner with whom she shared a child. But here's the thing. Despite drifting in and out of consciousness, Hunt continued to speak, providing crucial information that would lead law enforcement straight to her alleged attacker. She described his vehicle, this white pickup truck with oversized tires, said he lived just outside of Chatfield, Minnesota. She also told officers the assault took place at a new boat launch in rural Kellogg, Wabash County. And Hunt was even able to clarify that her attacker used a stick, not a bat. But despite her bravery and her determination to help police, Melissa Hunt's injuries were too severe. She died at the hospital less than 2 hours later. The complaint reads that the attack was described as a brutal blunt force assault, but what unfolded next took an even darker and more bizarre turn. And I'm going to get into that in a moment, but first I want to bring on a special guest, friend of the show, Anthony Osso, criminal defense attorney, former assistant district attorney, has a specialization in these kinds of cases. Anthony, so good to see you. Thanks so much for taking the time. You know, when I was reading about this case and we were doing the work on this case, the first thing that I think about, other than the horrifying aspect of it, is dying declaration, right? Given that the victim was able to communicate before dying, talk to us about what that means from a legal context, a hearsay context.
Sure. So one of the most common known rules in trial is hearsay, right? Out-of-court statements can't be used in court to prove certain matters. And so an exception to that rule would be a dying declaration. And it sounds like, based on the statement of facts, Jesse, that that's exactly what we have here. She's on her deathbed and she's able to get out before she dies important things about how this death was caused. And so that's an exception to the rule and can likely come in trial.
Meaning it's more reliable. In that situation,
Yes.
It's more reliable. A jury can take away from that what she said in her final moments, it was credible, it was reliable, it's supported.
Absolutely.
Now, can they move forward with the case purely based on these statements? I mean, at the very least, probable cause for an arrest and subsequent charges?
I think that they could, but I don't think that that's what they're going to do. And I don't think that would be the best idea. There's a lot of things that they can do in their investigation based on what she said, right? And so it sounds like that's what they did, but I don't think they would try the case on that kind of statement alone.
By the way, little sidebar here. Have you ever left a meeting and think, what did we just talk about for the last hour? Maybe you've been in the middle of a great conversation. You're like, I wish I could take out notes without, pulling out my phone or typing away like a maniac. I know I've been there. Well, I'll tell you what, we now have Claude NoPin, okay? This tiny wearable AI-powered device that has changed the game. So I wear mine as a wristband, but you can also clip it on, a pin, hang like a necklace. During law school, during my early days of my legal career, I could have really used something like this, even now as a host. It's a total cheat code. So whether it's meetings, interviews, quick brainstorms, the NoPin catches everything. It transcribes in 112 languages, it automatically tags speakers, and it drops everything into this clean, digestible summary. There's no more messy notes or lost ideas. It's not just a recorder, by the way. It actually acts like a hands-free assistant, pulling insights, organizing information, letting you stay fully in the moment. So if you want to make the most of your time, it's time to try the Plod NoPin. Right now you can get 10% off. Just click the link below or scan the QR code on screen. Hope you can check it out. Generally speaking, if you're looking at something like this, what would classify a case as first-degree murder as opposed to, let's say, second-degree murder?
Well, Jesse, when you look at Minnesota law, it really comes down to the circumstances of the murder and whether there was premeditation involved. And so first-degree murder requires premeditation with intent to kill, meaning that there was a plan taken out in order to affect someone's death. Second-degree murder doesn't require premeditation. So there just has to be an intent to affect a certain person's death, or there has to be the commission. You have to cause someone's death during the commission of another felony. And that's how they filed these cases in this case.
Generally speaking, again, if the victim is a ex-girlfriend, ex-partner, mother of a child, right? Mother of his child. Is that an aggravating factor?
I think it's aggravating from a punishment aspect, but I think that oftentimes it opens up the door for the defense to argue sudden passion. And I think that's what probably the prosecution is contemplating in not filing first-degree murder charges in this case.
By the way, from a defense perspective, we talk about how that statement can come in or the statements can come in. But if you don't have the witness to cross-examine, how do you challenge it as a defense attorney?
You'd argue confrontation clause violation. So under the Sixth Amendment, any defendant in a criminal case has the right to confront their accusers. And if the witness isn't present in trial, then the defendant is deprived of that constitutional right. There are exceptions to that rule. And so that's probably something that the defense is going to raise if this case goes to trial, and that the prosecution would really have to work hard to work around.
Could you also question the officer or officers? Hey, is this exactly what you heard? Where were you when you heard this? How do you know for sure she was saying this? Is that something you could do too?
Absolutely. You would want to look at the summary of their statements. And in this day and age, it's very likely that any officer that took a statement from her had a body-worn camera on. So it'll be interesting to find out whether that was a recorded interview or whether that was recorded on body-worn camera. So the defense might not have the ability to raise questions like that if it's on video. But if not, that's certainly something the defense should attack on cross-examination.
It's a really good point. Really good point about the body-worn camera. So look, after Hunt apparently tells police that this attack allegedly occurred at a boat launch, police rushed there, right? When they arrived, there was no weapon, there was no blood, there was no clear sign of a crime. Why? That scene had been wiped clean. But you know what it was from? Yeah, I say wiped clean, you already might be making a conclusion. Not exactly. There was a torrential downpour that had rolled through during the search. According to responding officers, heavy rain had likely washed away any remaining evidence. But the thing about that is the trail wasn't cold for long. Why? Law enforcement, they quickly issued an alert to locate Hameister's vehicle, this white 2017 Chevrolet Silverado pickup. That truck was soon found outside of a home in Chatfield, which is nearly 40 miles from the crime scene. But the house didn't belong to the defendant. When officers arrived and questioned the person living there, they uncovered chilling new details. According to the criminal complaint, quote, the truck had its door open and law enforcement observed a live 9mm round on the floor. The truck doors were shut and the property's residents were interviewed. Law enforcement was told that the defendant had recently showed up at the property. The defendant appeared very frantic and the defendant stated something bad happened. The resident was also told that the cops would be coming. Now the house where Hameister's truck was found wasn't his own, though the criminal complaint doesn't specify exactly whose home it was. What is clear, however, is that the woman living there told investigators that her 9mm handgun had gone missing and that the defendant had fled her property on a motorcycle. And that revelation triggered a full-scale manhunt. And by the way, just wait until we get into how the suspect attempted to evade police. Now, before we get there, okay, we'll get into it. Anthony, the loss of physical evidence at this alleged crime scene due to a storm, not even human intervention, how does that affect the strength or the weakness of a prosecution's case?
Well, under most circumstances, it wouldn't be good. but it sounds like the defendant didn't do himself any favors based on the statements that he made to these people at this residence. So there's a lot of other things that the prosecution can hang their hat on, but certainly without that kind of evidence, you'd want to look at DNA to prevent the defense from raising an identity defense, and that could be very problematic in a case.
And the discovery of the live 9mm round in the suspect's abandoned truck, how is that handled in terms of chain of custody, evidentiary value, especially, by the way, if no firearm had yet been recovered?
Yeah, I think the existence of it, especially when coupled with the dying declaration of Miss Hunt in this case, is important. But again, chain of custody is always important. And without a gun, there's no way to really compare whether that casing was fired from a specific weapon that was taken from the residence.
And the resident reports that the defendant appeared frantic, admitted that something bad had happened. How strong of a statement is that in court? How would a defense attorney work to minimize it, suppress it in some way?
I think the ability to suppress it would have to do with relevance in that they didn't know what was going on at the scene with Miss Hunt, but I don't think that objection is probably going to work. If you look at the timeline of events, it's so close in proximity to when the police met Miss Hunt, and she was so badly beaten that most judges, I would anticipate, would let that kind of statement in. And any statement of a defendant can be used against a defendant in a trial. So I anticipate that evidence would come into play, be difficult for the defense to overcome that hurdle.
And the suspect allegedly leaving, right? The flight, leaving the vehicle, leaving his vehicle, leaving on a motorcycle. You can interpret that reportedly evading law enforcement. I imagine the prosecution would say that's consciousness of guilt right there. How would the defense try to frame it differently?
Without all the circumstances, it's hard to say which direction they want to go. And if we haven't seen all the physical evidence yet, I know that there was rain, and I know that there's probably an issue of finding the firearm, but they might not go the identity route. They might go and they might use it to sort of, I wouldn't say insanity defense, but use it to really lean into the fact that he was having issues at the time, I would lean into the franticness of his behavior to say that he was having sort of an episode and try and mitigate the punishment that way. I think it's a hard hurdle to overcome when there's a dying declaration, a statement against him, that's really not in his best interest to another witness, and then evading from law enforcement, which the jury can use as consciousness of guilt. It's really kind of stacks up against the defendant in this case.
So what happens? Well, authorities, they track the suspect to Chester, Minnesota, which is about a 20-minute drive from Chatfield. And when officers closed in, that is when the situation quickly escalated. The complaint describes just this chaotic scene. Quote, he was pursued by law enforcement and climbed a tree to evade arrest. He was ultimately apprehended after an hours-long standoff. A 9mm handgun was found at the base of the tree that the defendant sheltered in. Now, in a scene that felt ripped from the pages of a crime thriller, the 44-year-old suspect was finally cornered deep in Chester Woods, where he had somehow climbed this tree, remained hidden for hours. You have this tense standoff. He was taken to custody, booked into the county jail, and now he faces a slate of serious charges. Second-degree murder with intent but without premeditation, second-degree murder without intent while committing a felony, and the next day, the autopsy was performed. And that, too, brought this unexpected and chilling twist. And we're going to get into that as well. But first, Anthony, back to you. This is quite a way to avoid arrest, climbing a tree.
It is. I think, again, to my earlier point, I imagine the defense is probably going to lean into the franticness of the defendant's behavior. Another route that they could go is that he wasn't aware of any injuries to Miss Hunt at the time and wasn't a part of that and make it an identity case. But that's where the part of the statement of the residents where the defendant says something bad has happened would really go against him. And I imagine that once that handgun's recovered, they will do testing on the casing that was recovered in his vehicle to try and create a chain, again, like you said earlier, a chain of custody, and establish that a shot was fired.
why two different murder charges, right? So you have one with intent but without premeditation, the other without intent while committing a felony. You talked about it before. I just want to button it up. Why two different ones? Is it, hey, we believe that his alleged conduct matches this? Or is it, if there's a weakness in one murder charge, we can get him on another one?
It's the latter, Jesse. This is CYA, and you see it oftentimes. There's no requirement that the prosecution pick one theory of murder. They can go on both counts in one trial. And so the way that they see it is that if, for whatever reason, a jury doesn't find, or the defense sort of gets a theory out that there was no intent to effect death, then they can fall back on the idea that, well, he at least intended to cause her serious bodily injury, which is a felony in the state of Minnesota. And as a result of that, or during the commission of that offense, her death occurred. And that raises it to felony murder.
By the way, I have to ask, it's a weird thing for him to allegedly do. I mean, running away. I have to ask if there's a mental health evaluation that would become an important part of this case. I don't imagine we're talking insanity, if that's even available, because if you're running away from law enforcement, allegedly running away from law enforcement, you know what you did is a crime. You have a consciousness of that being a legal action. But I do wonder if a mental health evaluation would become a part of this case in some way.
Absolutely, Jesse. I think the defense would be remiss in their responsibility to the client if they didn't have him evaluated. I think it would be, and we don't have all of the facts yet, and it might be
sure
kooky for them to argue that he was running away because he thought didn't know they were law enforcement, or he thought that they were trying to attack him, or for whatever other reason aside of a consciousness of guilt. But I think the defense has to have him evaluated based on the circumstances in this case. And if it's not a defense to guilt innocence, it's certainly something they could use for mitigation and punishment.
Nope, that's a good point. Now I got to go to this autopsy result, okay? This is really interesting. So, according to the complaint, quote, the facial wound of the victim has gunshot residue embedded in the wound, meaning, was Hunt actually shot in the face? That's the part that seems a little strange there, Anthony, because she said she was beaten. Unless she was beaten with and she said it was with a stick, but did the stick have gunshot residue on it? That's the part I don't understand.
Well, and that was my confusion too, is I don't understand if there was a bullet wound in her jaw at any point. Typically, when you're looking at autopsies and you're with gunshots, anytime there's gunshot residue inside a wound, that's a good indicator that it was a shot that was fired really close to the person that was shot. And so that led me to think that there might have been a gunshot involved. However, just because there's, even if a gunshot is fired near a person, there's a possibility that could end up, or gunshot residue could end up on the wound. That you see that all the time. Even if someone's not shot, they still have gunshot residue if they were around a gun being fired.
Just a weird detail about this. Now here's another interesting bit of background information here, and it has to do with an ongoing custody dispute. So months before Melissa Hunt was brutally killed, court records show she was locked in this bitter custody and child support battle with the defendant, the same man now accused of her murder. And newly obtained documents reveal that Mr. Hameister was ordered to pay $660 per month in child support for their 3-year-old daughter. And after a court hearing where Hameister didn't show up, by the way, Hunt was granted full custody while he received 0 parenting time. According to the March 2023 Olmsted County order, Hameister, a tree trimmer earning $25.34 per hour, was slapped with $2,961 in back payments for late support. The court stated ability to pay is based on the respondent's parental income. Liability is limited to the 2 years immediately preceding the action. Hunt, a caregiver making $15 an hour, relied on $110 per month in housing and while raising the child solo, and the order threatened Hameister with felony charges for withholding the child support, wage garnishment, even license suspension if he failed to pay. And the filing exposes the raw tensions. Hunt had 100% custody. Hameister wasn't granted a single overnight visit. A stark warning in the order read, denial of parenting time is not an excuse for non-payment. Now, Hameister's family told media outlet KTTC that the couple had this unstable relationship and that while Hameister didn't have any history of domestic violence that they knew of, he did have past issues with drugs. Anthony, how often do we see disputes like this factor into cases involving alleged domestic violence or, even homicide? My gosh, if you talk about a potential motive for prosecutors, I think they have it.
A large percentage of them, Jesse. I think it's a custody dispute can kind of be a textbook entryway or introduction into turmoil between any relationship. And you do see that oftentimes result in violence down the road, not necessarily to the extent that Ms. Hunt endured in this case, but it's oftentimes a segue into violence.
So his bail was set at $2 million, scheduled to make his first court appearance on July 3rd. If he's convicted of second-degree murder, he could spend up to 30 years in prison. This is a horrific case with horrific consequences, and we will see which way it goes. Anthony Osso, thank you so much for taking the time. Really appreciate it.
Thanks for having me, Jesse.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.